Hi, I'm Bill Andersen, and I'm going to talk a little bit tonight about the latest term of the United States Supreme Court. It's been an interesting term. There have been some major cases that have been hanging fire for several years, and they finally got decided, mostly. We had some unusual procedures in the court with oral arguments by the attorneys being held by telephone because with the virus, we can't have meetings in person anymore. And that changed the nature of oral argument quite considerably, to everyone's distress, really. We're also interested in this term because it's going to show us a little bit about who Justice Roberts is and what effect he's having on the court. Now, I must tell you that some of the cases this time are pretty technical, and I'm trying to keep them from being too much down in the weeds for all of us, but there are a couple of technical things I'll have to talk about. So it's going to be kind of interesting to get to the bottom of some of those things. Just a word about the court itself. You saw the picture of the building on the title page. It's a beautiful building, and if you haven't been to visit the court sometime, back in the days, or when the days ever come and we can go visit stuff like that, do take a chance to walk into the place. It's an extraordinarily impressive building. The white marble columns and the black leather furniture and the red velvet draperies and carpets. It's a very impressive place, and it really has a palpable effect on people as they walk in. So do have a look at it sometime. The court, as you know, is at the apex of our judicial system. Cases come up to the court for both federal and state courts, and they can handle all kinds of federal issues and constitutional issues that arise. They get about 80,000 petitions for review every year, and with just 9 justices, they can only get about 60 or 70 cases actually decided in a year. So they're highly selective, and so they take cases that are especially important because of the doctrine that is required, or because the lower courts are divided on important questions, and we all need to know kind of what the rule is, and for that reason they might take a case just to settle some uncertainty. So tonight I'm going to start with a brief summary of a couple of kind of interesting cases, just briefly, and then I'm going to settle down to a more intensive look at 4 categories of cases that make up the bulk of the court's really significant work. A couple of cases on the executive power, several cases on religion, which has been a big issue this year, more abortion cases, we seem to have them every year, and then of course immigration. So those are the 4 general categories we'll be examining with respect to my guess as to what the most important decisions are. But first, a couple of brief summaries of some cases. In a case called McGirt, the court upheld the claim of certain Native American Indian tribes that the Oklahoma land, which was given to these tribes in exchange for their agreement to leave their homelands in Alabama and Georgia back in 1830 or so, and move all the way to Oklahoma, which is where they were, quote, relocated. The promise made to the Native Americans was that this would remain Indian land forever. And that came up to this term. And the question was, is it Indian land in the technical sense that the state of Oklahoma could not enforce its criminal laws on the reservation with respect to members of the tribe? And the state conviction of a tribe member for a criminal offense was reversed because the court held 5-4 with opinion by Justice Gorsuch that a promise is a promise, and we promised them this would be Indian land forever, and it is still there. So it is still Indian land. 19 million acres, the eastern half of the state of Oklahoma, is still Indian land, and that has several legal consequences, and one of them is the criminal procedure jurisdiction. This is as you will know, those of you who are familiar with this is a long and tragic story about these Indians. Some 100,000 of them were sent on what is known as the Trail of Tears from Alabama out to Oklahoma back in the 1830s, and it's a sad part of American history. Why Justice Gorsuch is such an expert on Indian law, which he turns out to be, We think it's because he's a Westerner, at least he grew up in Denver. He became Easternized, I suppose, with his trip to Oxford and his Harvard Law School and his practice in Washington, D.C. But he started in Colorado, and so he's a Westerner. And there are those who think that Westerners understand Native American issues and cases better than those East Coast liberals. So that's an interesting case. It's a whole series of interesting cases on voting rights. As you may know, there have been a lot of activity in states, particularly in the South, to impose restrictions on voting. The hours that the polls are open, where they are, how easy it is to find them, what identifications you need to have with you before you're allowed to vote, et cetera, et cetera. And a lot of these have been challenged as being really intended to reduce the number of people who vote. And a lot of that litigation has wound up in the courts, including the Supreme Court. So far, we don't really have a ruling, a strong ruling from the court on those things. The court simply it has granted stays in some of the lower court injunctions against these things, so the election practices have been continued, and the court seems to be taking it on a sort of basis of it is too soon or it's too late with the election coming up to do much about it right now. We're not quite sure. We're not going to get something, I'm sure, in the way of major decisions before the November election, because the court is in recess now and does not open for business technically until October. But this is something that there's been a lot of business about. Another interesting case that came up, and this was interesting in part because of the clues it gives us about how judges differ on how to interpret language. There's a provision in the Civil Rights Act, Title VII. This is the 1960s Act, which forbids discrimination in employment on the basis of sex. And now the question arises whether that includes a discrimination, a prohibition against discrimination on the basis of gender identity or sexual orientation, not sex in the normal sense of the word, but obviously sexually related categories. And so the judges had to decide whether discrimination on the basis of sexual orientation and gender identity, which now are live issues that they weren't in the 1960s when the Civil Rights Act was passed, they are now. And they had to decide whether discrimination on the basis of identity and orientation are because of sex, which is prohibited. And 6-3, the court decided that yes, those kind of protections were still built into the Civil Rights Act, even though the drafters of the act could not have been thinking about these particular applications. Some judges look at a language in a statute and say, well, they didn't think about this particular topic when they chose that word, but the topic is here now and it fits within the normal meaning of the word. Let's go ahead and assume that if they had it to do over again, they would have included this. And that's what we have in the 6 people who voted to apply the Civil Rights Act to discrimination on the basis of gender identity and sexual orientation. The dissenting judges, the 3 dissenting judges, in this case, the dissent written by Justice Thomas, took a position that Justice Scalia was most famous for, and it is that, well, Congress didn't say this. They made a terrible mistake not saying it, but they didn't think about it, or they weren't smart enough to understand it when they wrote the statute, so it has to be corrected. But it is not the function of the court to make that correction. It's the function of Congress. Let's leave it alone, apply it the way it's written. If Congress doesn't like it, they can change it. That means that the decision as to what the statute means is determined by a democratically elected Congress, not a life-tenured federal judge. So that's an argument that is always going to be going on, and it came up in this case. And the last of the miscellaneous cases is the Washington case about the faithless electors. As you may know, when we're having a presidential system, we use this electoral college system, and each state selects electors, and they are supposed to vote for the candidate who won the popular vote in that state. Well, in 2016, we had 3 electors in the state of Washington who, instead of voting for Hillary Clinton, who won the popular vote, they wrote in Colin Powell, and they were fined $1,000 each for that conduct, and they challenged that, went all the way to the Supreme Court. And a unanimous court said, yes, states are free to punish faithless electors if they like. It is up to the states to decide whether the electors have to comply with the notion that their vote should be cast for the candidate who wins the popular election in the state. If the state cares about that, as Washington did, and imposes a fine for electors who don't comply with that preference, then it's okay for Washington to do that. So these electors had to pay their $1,000 fines. So, okay, let's move to the major cases now. As I said, there are 4 categories: executive power, immigration, abortion, and religion. And let's start with executive power. There are 2 major cases on executive power. One of them you all know about, and one of you may not have heard about. Let me start with the latter. The Consumer Financial Protection Board is an administrative agency created during the Obama administration at the instance of a professor of law at the Harvard Law School by the name of Elizabeth Warren. You may have heard of her since. Her field was consumer finance and bankruptcy, and she did a lot of research and discovered there's a lot of fraud out there among lenders, payday lenders and mortgage lenders and banks, a lot of things that consumers couldn't deal with very, very well. And so she recommended to the president that an agency be set up. We've got lots of agencies doing lots of things, but we didn't have an agency that had the expertise or the knowledge or the bandwidth, as they would say now, to deal with this particular kind of consumer protection, namely that involving financial instruments, which get very complicated and very sophisticated. So the president urged Congress to set up the agency, and Congress did set up the agency. And now Elizabeth Warren was not named director of the agency first because Obama said he couldn't get her ratified, confirmed by the Senate, because she was a bit of a firebrand, but he did make her special assistant to the president for consumer finance. So she was involved in all this. And I'll tell you that as of 2017, the New York Times reports that the agency had returned $12 billion, that's billion with a B, $12 billion to 29 million consumers in the way of refunds and canceled charges. So there's a lot of business out there to do for this kind of agency. Well, the issue by the agency for some sort of alleged consumer fraud was that the statute was unconstitutional because it took away from, I guess is the way to say it is, it took away from the president the power to fire the director. Most of these agencies, they're in the executive branch, thousands and thousands of people in the executive branch. About 4,000 of them are subject to presidential appointment. There's 4,000 major folks in the executive branch are appointed by the president, and they serve at his pleasure. And he hires somebody to direct this, and he doesn't like what they're doing, he just fires them. And that's, and we see a lot of that these days, in fact, more than we're used to. But now and then Congress would say, well, we don't think the president ought to be allowed to fire this person for no reason, because we want the person to follow our policy preferences here in Congress. And if the president caves into some special interest group and fires an administrator who's doing the job we think they ought to do, we think that's a bad idea. So we're going to write the statute. The director is appointed by the president, as all principal officers have to be. But this particular director was going to have a 5-year fixed term and could not be fired except for cause, which means some criminal offense or some really serious matter. Couldn't be fired for policy differences with the president. And that is quite unusual in the executive branch. And the charge was made by this company that violates the Constitution. And in a 5-4 decision by Justice Roberts, the attacker of this won that argument. Roberts said that Congress cannot limit the president's removal power because the president is charged by the Constitution with faithfully executing the laws, and that cannot be done in a situation in which he does not have the full confidence of the leaders of his agencies, and he's got to be able to fire them when he thinks they're not doing the right job. and that's a constitutional requirement, and Congress cannot limit his removal power by giving people fixed terms of office or providing they cannot be fired without cause. So that's illegal, that Congress cannot do that. Now, I will tell you, there are a couple of cases in which Congress has been permitted to do that. One, only a couple, as I say, almost all the 4,000 people the president appoints serve at his pleasure, and that's understood. But there have been a couple of cases in our history, one in the 1930s and one much more recently, in which Congress was able to limit the president's removal power and say this official cannot be fired by the president until the end of their term, and no matter what his disagreements are. Now, you think of what Roberts might do in that situation. He's got these two other cases that permitted Congress to limit the president's removal power. He could have overruled them and said, well, that's not the rule anymore. But overruling precedent is something Justice Roberts is very reluctant to do. So he didn't overrule them. He distinguished them. He said, well, those two cases are different. The agencies involved in different structures. There were other protections involved there that are not involved here, et cetera, et cetera. He gives a long list of reasons why those cases are different. And so they don't require the result in this particular case. I think it's a Roberts technique to go incrementally in small steps. And I think that's part of what he's going to do for the court. And I think that's what he's doing here. So the company that raised this objection about the president's removal power said, well, since that part of the statute is unconstitutional, the whole statute has to go. And Justice Roberts said, no, that's a bigger step than I'm comfortable taking. I will sever this removal provision from the statute. And the statute now says, the agency still has all the powers it had before. The president still appoints as before, but the president can remove, as was not possible with the provision that statute was drafted with. So again, Roberts doesn't go all the way. He goes part of the way and leaves this agency in place. And from the numbers I cited a minute ago, it sounds to me like we need an agency like that. There seems to be a lot of work to do. This argument, incidentally, about the power of Congress to limit the president is a long historic battle that's been going on from the beginning of our republic. And it is not likely going to be over, but there's a whole school of thought that thinks the president ought to be virtually free of any congressional control so that we can really get vigorous enforcement of the laws and vigorous executive functions in the system. A lot of other people think, well, no, we think Congress is a much more democratic body. And so there ought to be some limits on what the president can do. This argument's still going on, but this is one in which the president seems to have won, and at least a 5-4 decision for this particular agency, the president is allowed to have his removal power unimpeded by congressional work. Okay, the other executive power case is the one you have heard about, and that's whether or not we can subpoena the president's personal financial record. As you will know, there were two subpoenas involved. One came from Congress, and Congress has the power to subpoena information in aid of deciding what kind of legislation to pass. Lots of investigative work goes on in Congress to figure out what is the situation and what problems are and what solutions seem to make sense. And if they can't get that information voluntarily from people, then the subpoena power is a way to get it anyway. So the court's very generous with congressional power to subpoena from private individuals. Does it matter when the individual being subpoenaed is the president of the United States? Well, the president said, of course it matters. The president is not subject to the subpoena process at all. The president is above the law in that sense. He doesn't ever have to comply with a congressional subpoena. Well, the court, as I say, remanded this for some other work, but 7-2, basically, the court said quite clearly that the president is not above the law. The president is subject to subpoenas from Congress, and for that reason, he better stop making those claims about absolute immunity. Now, nobody ever really believed that the president was above the law. That violates our history from the Revolutionary age on, and we've had debates about this Jefferson had debates with John Marshall back in the early 1800s when John Marshall subpoenaed President Jefferson some documents and his personal appearance in a trial that was being held for Aaron Burr's treason charges. And Jefferson said, I'm the President of the United States. I'm not subject to your subpoena, Mr. Justice Marshall. And I'm not going to show up in your courtroom, Mr. Justice Marshall, because I'm the president and I'm immune from all that stuff. But fact is, Jefferson did provide the records. He says voluntarily. So we're not going to draw a line in the sand there. We're just going to say, yeah, you can have the records, but not because you have power to get them, but because I voluntarily choose to give them up. That argument's, and he did not show up at the trial either in subpoena. And what did John Marshall do? Nothing. John Marshall didn't mention it. So again, nobody wants to draw lines in the sand in this kind of setting when you have to. So we've never had any very clear doctrinal analysis, but it's been going on a long time. And as I say, nobody really believed that the president can be above the law. We saw President Nixon had to give up the tapes in response to a subpoena. President Clinton had to give up some documents in response to a subpoena. So everybody understood that. There was no claim that the president being totally above the law was never taken seriously by anybody. But it is the case that the president is not an ordinary person. And it is the case that the president has some very important functions, and we shouldn't apply the subpoena law, which has a lot of discretion in it, in a way that impedes the carrying out of that executive function in a good way. So what Justice Roberts does in this opinion, he sends it back for further review, but what he says is the president is not immune, but in applying the subpoena law to the president, you have to consider a lot of factors because he's not an ordinary person. You have to consider separation of powers problems. You have to consider things like, why does Congress want this information? And if the court has a sense that Congress wants it not in aid of some legitimate legislative purpose, but they want it simply to embarrass or harass the president, it's much less likely that a subpoena that characterized will be enforced. So it's a factor that has to be considered. How necessary is the information? The court may want to know. If the information is available someplace else, then you don't have to bother the president for it. How broad is the subpoena written? Does it include stuff that Congress has no legitimate interest in passing laws about? You can have information about the president's financial records because you may want to know who paid whom about, some foreign person trying to influence an election, etc. Those are all legitimate areas in which Congress can inquire. But if you start inquiring into the marital difficulties of the president, Congress has no power over laws about marriage and domestic relations. That's just entirely a state matter. So it's not a legitimate thing for Congress to legislate about, and therefore it's not a legitimate thing for Congress to use subpoenas to get information about. The question of how much the burden is on the president to comply with these things, never a very persuasive thing for presidents. They always say, it'll take me forever to get all this stuff together. I'm trying to work out a major treaty on test bans, nuclear weapons, or I'm trying to save the environment from collapse, and I haven't got time to look for all these papers. That has never been a very persuasive argument. The court is aware that the president has staff people to do all that for him, and so compliance burdens have never been very heavily concerned by the court. But the fact is, the court is telling us the president is not above the law, but he is not an ordinary person. And there may be some documents that an ordinary person would have to give up that the president doesn't have to give up because of his particular situation. Much the same thing happened in the other subpoena case, this not coming from Congress, but coming from a state attorney general who was proceeding in some criminal cases with a grand jury and needed some information that the president had. And I think the court got a very similar, they're technical differences, but a similar answer. That is, the president's not immune from this stuff. The president may have to disclose this stuff, but you have to consider some other factors a little more carefully than you did in the proceeding below. So you have a 6-3 opinion here. And so I think it's a little better than 5-4 in terms of uh, how it works out on the court. So the presidential power, the president wins one of those cases in the Consumer Financial Bureau case, and the president, I think he was put in his place with respect to the subpoena power. He doesn't have absolute immunity. Now, notice the timing on this. We don't see president's tax returns before November. Now, because we go back and remand, they have to consider all these factors and blah, 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 blah. There'll be a lot of delay, and it seems to me very unlikely that you're going to see any tax returns of President Trump before November. So maybe the president really won in terms of the timing of it, but on principle, he didn't. So the executive power cases, the two of them, he sort of does better in one than he does in the other. The second major category after executive power has to do with religion. We've had a lot of cases about the relationship between religion and the state in the last 20 years. I mean, it was a full docket of them this time. There are three major cases that were decided this time in the religion and state relationship area. And I will tell you that I think the church wins all three of these cases. They're all in different areas and different issues. But it seems to me there's kind of a tendency these days on the part of the court to permit the government to impose benefits, to grant benefits to churches that they might not have granted before on the grounds that it violated some separation principle, or to impose burdens, less likely to impose burdens on religions that they might have permitted in the past. So I think we're in the middle of a sort of general drift in the opinions in favor of the churches and the religious institutions that are involved. You may remember, if you were around last year when we had this conversation about some other cases, the federal Constitution provides two things about religion. One, that Congress shall establish no church. And number two, that Congress shall not interfere with the free exercise of religion on the part of individuals. Those are all in the First Amendment. They're binding on the states now. And so the first one, which we call the Establishment Clause, really turns out to be an argument that you cannot confer benefits on religion too much, because that looks like you're establishing a church. So how much can you impose? Well, obviously a lot of benefits that churches get when Father Ryan calls up the police department and says, or the fire department, and says, St. James is on fire, can you send a fire truck over? He's not met by the dispatcher saying, I'm sorry, Father Ryan, but the First Amendment says we cannot benefit religions with tax money. And that doesn't happen, obviously. So there are a lot of social services that churches get: police, fire protection. They get tax immunities. They get all kinds of other things, all kinds of other benefits provided by the state. But it doesn't amount to the establishment of religion. And as I say, I think the court has been more and more generous, permitting more and more benefit to churches than was true 20, 30 years ago. The other part of the First Amendment that deals with this is the Free Exercise Clause. What kind of burdens can you put on religions? I think the court has been not as permissive in allowing state to put burdens on religions as they might have in the past. Now, there's some obvious burdens that have to be put on religions. You can outlaw polygamy, for example. You can outlaw the use of hallucinatory drugs. You can outlaw some other things. But by and large, if you start restricting religions too much, you're going to run into a series of judicial opinions and statutes now, which make it harder to impose burdens on religions unless there's a very strong case for it and no more limited alternative is available. So that's the doctrinal area we're working in here. The cases that we can talk about now, and I think as I said, I think there's a trend going on now in which more burdens are permissible to churches and fewer burdens are permitted to be imposed on the churches. And I think this is a general trend that you can sort of see in the doctrine. Let's talk about these three cases briefly. One of them is the Espinoza case. And this is a case in which Montana has a tax program granting credits to donors, tax credits to donors who provide gifts to organizations which provide scholarships to private schools in Montana. There's a lot of words in that sentence, but it has it's a complicated system, but just think of it as a tax credit for people who are contributing scholarship money to private schools. Clearly a benefit to the private schools, and clearly a benefit to that cluster of that part of the private schools that are religious schools. And so you may say, well, that's not possible under the First Amendment. It's a benefit. Well, Montana has a constitutional provision. Let me read it to you. No state or local government shall appropriate public funds for any sectarian purpose or to aid any church, school, academy, seminary, college, university, controlled in whole or in part by any church, sect, or denomination. That's in the Montana Constitution. And I will tell you that there's a provision almost word for word like that in the Constitution of 30 states, anyway, 30, including Washington. We'll talk about that in a minute. But so Montana has this program for getting scholarship money into private schools, and most of the private schools in Montana turn out to be religious schools. And so the question is, can that scholarship program work if it's going to put money into religious schools, clearly in violation of this constitutional provision? And the Supreme Court of Montana said, yes, you can't do that. The Constitution is very clear. You can't aid churches. This is an arrangement which is going to aid churches, and so it's not good. That decision is reversed by the Supreme Court, again, 5-4, with an opinion by Justice Roberts. And they didn't even talk about the Establishment Clause, the fact that these were burdens that were being, or these were benefits that were being given to the churches. That argument didn't even warrant getting argued in any serious way. Nobody made that claim. The claim was that if you had this system, it would discriminate against religions. If you took religions out of it, if you said, okay, you can have a scholarship program for private schools, so long as none of that money goes to church schools, and we have to do that, Montana would say, because we got this constitutional provision. And I think what the court says here is that there's simply no, that is an interference, a burden imposed on religions because they're religions. And these organizations are excluded from the scholarship benefit because they're churches. And that is an interference with people's free exercise of religion under the Free Exercise Clause. So you can't impose that kind of a burden on a church, refusing to give it this scholarship support. And the court talks about some of the other cases that have permitted that. You remember from last year, the court said it was okay to have a program that provided low-cost schoolyard paving under a program, even though you were a church school. And it was claimed that, well, that's a benefit to churches that the First Amendment prohibits. And the court said, no, if you exclude churches from that program, you are interfering with their free exercise of religion. You can't do that. So that case, the Trinity case, and that didn't involve anything quite as close to the heart of religion as scholarships to schools, but nevertheless, it laid down a marker. I think that the court's going to be quite reluctant to permit that sort of discrimination against religious organizations or churches. What that means is that states can continue to extend aid to religions without fear of an Establishment Clause violation. Now, we're not sure if they get over to the point where the state wants to pay the salary of the priest and at Father Ryan's salary, that might be a little too close to religion. But talking paving the playgrounds is okay, providing scholarships for students is okay, and we've seen lots of other things, tax immunities and textbooks and other kinds of things that the state can provide for churches. So, and I think that area is going to be broadened, and then the court is going to be less likely to strike them down on the grounds that they violate the Establishment Clause. And similarly, the Espinoza case that we're talking about now makes it pretty clear that if you have a benefit program and you exclude organizations from it because they are churches, you're going to wind up with a free exercise claim. And so there'll be less of that. And the third consequence, it seems to me, other than satisfying the Establishment Clause and the free exercise clause, the other thing that this seems to say is that state constitutional provisions like Montana's and Washington's, which forbid aid to religions, cannot be enforced under the First Amendment of the federal Constitution in that way. So it's going to be a dicey proposition when state legislatures start coming up with ways to provide benefits to organizations and try and exclude churches on the grounds that our Constitution forbids aid to churches. I think they're going to find that they're going to run into First Amendment problems under the federal Constitution. So I think the churches are happy about that outcome. So I think we have this notion that this wall of separation between church and state, which is a phrase not in the Constitution, it's a Jeffersonian phrase from a letter written a long time ago, but it's a metaphor that we all kind of like, the wall of separation. It's getting more and more porous, that wall, and so it may be that it's just another example of that notion that walls don't work very well. The second case, the religion case, is the Guadalupe case, and this is an interesting problem, and you might not have thought of this before, but our churches, which are supposed to be free of government control, nevertheless subject to laws that apply to everybody else? And the answer is mostly they are. Father Ryan has to obey the speed limits, and what about how they treat their own employees? Does a church who employs people for various jobs have to pay them minimum wage? Does a church have to pay Social Security tax for these employees? Does a church have to comply with child labor laws? Does the church lose its nonprofit status if it discriminates on the basis of race? The answer to all these questions is probably yes. That is, the church is an institution in civil society and has to comply with laws that are generally applicable to everybody else. Now, there will be a couple of laws that they can't really comply with very easily. If you have the Civil Rights Act that says you can't discriminate on the basis of religion, and you tell a church you can't refuse to hire a Baptist because you're a Presbyterian church and you don't want a Baptist as your minister, that's not going to work. You're going to have to be able to discriminate in hiring in a church on the basis of religion. That's the way the churches work. And so the ADA has some other things. The Disabilities Act has some excuses for some places where the rules are different for if the party involved and the employer involved is a church. So you've got a couple of statutory exceptions there of generally applicable laws that do not apply to churches because Congress has said so. A much broader exemption of the generally applicable laws to behavior of churches, a much broader one, and it's a judge-made principle. It's called a ministerial exception. If the organization is a religious organization and not a church as such, which may be exempt from the stuff by the reason of the statute, but nevertheless it's a religious activity, then what do you do when they're trying to select people to run their activity and run afoul of one of these things? Take a church school, for example. It's not a church. It's not exempt from the usual rules about discrimination on the basis of religion. But suppose the church school says, we only want to hire janitors and other folks, people, food service people and so on, who are members of our church or who are at least devotees of our religion. Well, that's a harder case, isn't it? I mean, this isn't a church, it's a school, But nevertheless, the same principles get tangled up in it. And the phrase tangling up, incidentally, is one that the courts use a lot. There's a very strong reluctance on the part of these courts to not get tangled up with religious questions. They don't want to get involved in a battle within a church. Who should be the minister? What sect and what schism? What issue ought to be involved in? That's not something courts want to do. They're going to stay as far away from that as they can. Well, here are two fifth-grade teachers in Southern California. They're fired, or their contracts are not renewed. One of them says they fired me because I was old, and that's a violation of the federal statutes. And the other said they fired me because I was sick. I was diagnosed with breast cancer, and so they fired me or didn't renew my contract, and that violates federal rules. And so they come to court and say the court can't do that. And the court says, the lower court said, well, the ministerial exception that we've decided is that if you're a minister, these protections are not available to you, and you people are effectively ministers. So the question is, what is a minister? And you can imagine what the oral argument in this case was like. The court holds that these two teachers are within the ministerial exception and therefore are not protected by these discrimination laws because they are, quote, part of the church structure, part of the church arrangement. And so at oral argument, the justice said, well, why are these people? Well, they're ministers because they are engaged in the education of children in religious subjects. And they pray with these children, and they take them to confession, and they do that sort of stuff. They don't have any legitimate ministerial functions in terms of being titled minister or having training in the ministry. That's not it, but they are involved in the religious development of the children's life, and that's enough, the court says, to put them within the ministerial exception. And then the questions start coming, and you can imagine the oral argument in which the justice leans over the bench. Well, this is all done by telephone this year, so a little different. But well, what about janitors? Is a janitor within the ministerial exception? Everybody seemed to agree that probably not. But what about coaches? Well, that's a little closer. They do pray before games and some of these things, and they're there to build the moral spirit and ethical sense of these people. Maybe they're closer. What about the church organist? And then I go down this list of hypotheticals. Well, in any event, we don't know what the answer to all those questions might be. But the answer in this case is that these teachers who are engaged in developing the religious life of these students along with their other educational stuff are within the exception. And that means that basically the school can discriminate against them on any grounds, hasn't it? That to religion. They can be fired for being old, they can be fired for being sick, they can be fired, whatever it is, they're just not subject to the protection of those laws. They are exempted by being within the ministerial exception. Justice Alito for the majority, let me just read the paragraph that's critical. When a school with a religious mission entrusts a teacher with the responsibility of educating and forming students in the faith, judicial intervention in disputes between the teacher and the school threaten the school's independence in a way the First Amendment does not allow. And that's, I think, the basic argument, that somehow you get tangled up in this stuff. And when the school has conferred upon these employees certain powers, certain responsibilities that have to do with the development, religious development of those children, the courts simply don't want to get involved in that. They just want to stay away from it as far as they can. Now, the justices in dissent, Justice Sotomayor and Ginsburg, don't like this outcome because it permits the school to fire these people for any reason they want and without any protections at all. And so it's an argument that those two justices said, you can have, it's okay if you say they can't be discriminated against on religious grounds, but you can't fire them because they're too old or because they're too sick, because that is not related to religion, and this exception shouldn't apply in this case. on those kind of facts. Well, it's again a win, I think, for the religious interests. And here again, the church is able to proceed against people on whatever grounds they like. Now, in fact, the school has claimed here these people were being fired or their contracts are not being renewed because of poor academic performance. We don't know. This never was in the trial yet. So, but that's what the schools claim. They weren't doing it because they were old, and they weren't doing it because they were sick. They were doing it because they were not renewing their contracts because they weren't good teachers. And that'll have to be determined at some other place. But so that's the Guadalupe case, and those are two of the three wins for the church. The third one, and I'll stop this list here in a minute, and it's amazing to me how, if you start to think about the number of contexts within which religious issues come up, they can come up in the course of firing a school teacher, they can come up in the course of scholarship aid to a private school. The case we're going to talk about now, the Little Sisters of the Poor, a great title, has to do with the Affordable Care Act, Obamacare, and whether or not a religious organization has to provide contraceptive insurance coverage to its employees. Again, this is quite different from the other two cases we've talked about. There's just this endless series of contexts within which religion and government get tangled up together. Okay, the Affordable Care Act, and it's the most complicated piece of legislation I've ever seen. The statute itself is 20,000 pages long, and then on top of that, there are many, many more regulations. And it's also in motion. It's also constantly being changed, constantly being added to, subtracted from. It's been litigated from the day one, and how people can understand what it's about, I'll never know. But we're not have to go into that now. I think we can find a simpler way to get the issue that we're talking about. Basically, the act says that large employers have to provide health insurance for their employees. There are 1,000 exceptions to that, but let's take that as one of the basic thrusts of the Affordable Care Act. Not just any insurance, but insurance has to qualify under certain standards. So it can't, for example, have to do with exempting pre-existing diseases. It can't deal with other things. There's standards that have to be complied with. One of the standards the statute says is the insurance coverage has to provide preventative care for women, whatever you might think that is. And there's nothing in the statute about contraception, but the regulations now that begin to implement and enforce the act immediately understood what was being talked about. And so the regulations provide that to qualify, the employer's insurance policy must give women employees the full range of contraception protections that are available under FDA-approved contraception devices, techniques, and procedures, of which there are about 18. I think the last count I saw. So there are 18, and some of them are not too expensive. Some are very expensive, several $1,000s. So there has to be coverage for any of those kinds of things, and it has to be at no cost to the woman. No co-pays, no deductibles, none of that other stuff. No out-of-pocket cost to the woman. The employer's insurance policy must provide that sort of coverage. Well, that's the way it works. Except if the employer happens to be a church. Well, we're going to have a little different rule about contraception for churches. So there's some special things there about churches. Now, we call this the contraception mandate because most employers have to provide contraception insurance to their employees. So it's a mandate. And the question is, are there any exceptions to the mandate? And if there are, who gets to make them? And so turns out that the Little Sisters of the Poor, and if you ever want a name to be in a litigation with, that's the name. It's great. Now, it turns out to be a great organization founded in France a long time ago. It's a bunch of nuns who get together to provide care for elderly poor. And it's a wonderful organization, but just as a title, it's terrific. If you were in the marketing business, you just kill for a title like that. And I will tell you that the Little Sisters of the Poor had litigated these cases in the Supreme Court several times, and they're always represented by the very, very best lawyers in the business. This term, they were represented by Paul Clement, who was a former Solicitor General, that tried hundreds and hundreds of cases before the Supreme Court, one of the best in the world, probably the most expensive in the world. But the Little Sisters of the Poor did very well in terms of their lawyer, and they won the case. Now, I'm not sure those are always the same, having the most expensive lawyer and winning the case, but it certainly didn't hurt them. He's a fine lawyer. Well, the problem is, if there's an exemption from this mandate for churches, Little Sisters of the Poor is not a church. It's a nonprofit organization made up of nuns who are providing these services to the elderly poor. So it doesn't come within any statutory exemptions that might exist. So they say they ought to be exempt anyway. And there's some litigation that comes all the way to the Supreme Court last term, 2 terms ago. It didn't get resolved then. It got remanded for some further work. But the question is, well, how do you deal with an organization like that? They have deep-seated religious beliefs that contraception is bad. Then why should they have to provide insurance coverage for that activity for their own employees? That's the argument that's made, and it's a way of the state making people do things that violates their religious beliefs, which is a violation of the free exercise clause if there ever was one. So, but they're not covered by any statutory exemption. So by the time it works out, and it's very complicated, many layers in the procedure here, but it is suggested that, look, we can't exempt you because the statute doesn't provide that, but we can accommodate you. So now we have an exemption and an accommodation. The accommodation means that if you file this document saying we don't want to provide contraceptive insurance to our employees for religious reasons, then that's fine. That'll take care of it. You don't have to do that. We'll find some other way to pay for this insurance. And I'm not quite sure what that is, and it depends on many, many other details in the transaction that we can't talk about. But the fact is that the employee is going to get the same coverage that she would get under statutory standard, because it would have to be cost-free, and it would have to embrace the full range of FDA-approved methods. And so the employee would not notice any difference if the Little Sisters of the Poor would comply with that accommodation technique. Send a letter to whoever and say, we don't want to provide this insurance to our employees, and that's fine. That's we have religious reasons, that's fine. And so somebody else will take care of that insurance. Don't ask me who. I haven't sorted that out. It depends on many, many facts we don't have. Well, the Little Sisters said that's not good enough. We think we're complicit in contraception if we even have to file documents. We think we ought to be exempt from the whole thing. There ought to be no contraceptive insurance mandate for us because it violates our religious beliefs. Well, that is in process of being litigated when, lo and behold, you and I elect Donald Trump president. Now, the Trump presidency decides, well, this exemption is a great idea. And so he broadens it. The exemption, the regulatory exemption, not the statutory exemption for churches, but regulatory exemption that applies not only to churches, but other companies, profit, nonprofit, publicly traded, private, doesn't matter. Virtually every company around can refuse to provide contraceptive coverage for their employees if their objection to it is either religious, which is what all the rest of the stuff has been about, or moral. So if a company has a moral objection to providing contraception, then that's enough. They're exempt. Well, that's the case that came before the court this term. And again, there's no resolution. It's sent back for some further analysis. But my point is just that this is a very complicated business. And the court said in this case that the president does have authority to grant exemptions. And not only that, but the procedure followed in this case went through the rulemaking procedures of the Administrative Procedure Act. The procedure was proper. So he has authority, the president has authority to broaden these exemptions to cover whatever. And also the procedure he used to give himself that authority was correct. But there were some other procedural details that hadn't been finished yet, and they had to go back and talk about those. So I think saying the president does have authority to broaden the exemptions and saying the regular procedure under the APA was okay is a win for the president and a win for the churches, depending on what happens in the later discussion of the other procedural defects that they found. Well, again, this is a case written by Thomas, 5-4, and the dissent, again, by Sotomayor and Ginsburg, said, Congress clearly wanted all women to have access to no cost contraception in all the ways that the FDA approves. And if this goes through and this broadening of the exemption to cover all these other kind of organizations, 75,000 to 150,000 women are not going to get this at all. And it's because all these companies, if they don't use the accommodation process that the Little Sisters was offered, but instead insist on an exemption, then nobody provides this insurance for these women. And you've got 75,000 to 150,000 women with paying for it themselves or finding some public way to have it subsidized. So Sotomayor and Ginsburg think it's a very bad idea to say that the president has authority to do this, but that's what the court holds. And so I think we'll see what happens next. Now, you know what's going to happen next. This will go back and there will be debates about whether the additional procedural requirements have been met. And about that time, there may be a change in administrations. And then what? Well, a new president, if we have one of those, might have an entirely different idea and could rescind this broadening of the exemptions, narrow it back down to where it started. And just uncertainty is the name of the game. We just don't know at this point what's going to happen. And it all depends on events that we can't predict very well. Well, those are the three cases that involve religion directly. And as I say, I think the churches won all three of them to the extent that you can find a winner in one of these cases. It isn't completely resolved. But okay, so we talked about executive power, we talked about religion. The third major category is abortion, which is related to religion, but it's a little different in this case. This case, abortion has been, as you know, been litigated forever. Almost 50 years ago, the court decided Roe against Wade and said abortion is a constitutional right. A woman has a right to do that, and states cannot make it illegal. And but since then, states have looked for ways to restrict the number of abortions, and the number of abortions is drastically being reduced. I mean, it's just a very steep curve. It's the one we wish we could find with the virus, but so that it gets to be a smaller and smaller percentage of abortions that are needed, and that's for a lot of reasons. But in any event, these states, some states, mostly in the South, but there's some others around too, that are imposing restrictions on abortions because they don't like the idea and they're opposed to it on various grounds. And most of them rooted, I think, in religious beliefs, but nevertheless, they are good faith objections to abortion. The way they do it, when the court has said it's constitutional right to it, you can't forbid it. But what's the state can do? Well, we can find some ways to restrict it. And so they have a whole series of 300 or 400 different techniques have been used in the last 10 years by states to do all kinds of things to restrict it, to make it more difficult to get an abortion, more expensive, more complicated, more uncertain, and so on. And these things are everything from you have to have your parents' consent, or you have to have certain identifications to do this, or the doctors are not able to do this unless they have to go through these hoops or those hoops, or the facility in which it happens has to have this equipment or that equipment. There are all kinds of things that sort of And while many of them, most of them, I think, are justified by the health benefits to the woman, a lot of them, just nobody can really find much in the way of health benefits. Well, 2 years ago, we had a case, came up from Texas, and Texas decided that a physician could not operate in an abortion clinic unless that physician had admitting privileges at a nearby hospital within a certain number of miles. And that the idea was, and it sounds good on paper, I think, that if something happens in the course of an abortion that requires hospital care, then the physician who's operating, since he has admitting privileges to this nearby hospital, can take the patient directly there and follow her and take care of her there with the additional equipment that's available in a hospital. And that makes sense. So for the welfare of the women, we need to be sure that the doctor who's doing the procedure in the clinic has admitting privileges in a close by hospital. Well, it turns out that the longer people looked at it, the less justification there was for that sort of thing. In the first place, almost nobody, needs hospital care in the case of an abortion. It turns out to be statistically the safest procedure anybody ever thought of in the medical world, much safer than childbirth in terms of the numbers. And so you never go to a hospital. And if some complication might develop, and that may be one in a huge 100,000 cases, that it would happen several days after the abortion. The woman would have gone back to her hometown or her home neighborhood. And if she needs hospital care there, she would much rather go to her local hospital than come back to the one that happens to be next to the clinic that was open. And so nobody really, not nobody, a lot of people believed that it was a good idea, but a lot of people did not. They couldn't find any benefits to the system at all. And indeed, how do you get admitting privileges to a hospital? Well, a lot of doctors tried to get it because they wanted to practice in these abortion clinics, and they couldn't get the admitting privileges because A, they didn't have enough cases. And that's an interesting irony, isn't it? Since you're so good at the abortion business that nobody ever needs hospital care, you never have had a patient admitted to a hospital. And if you didn't, they're not going to give you admission privileges. That's a tough one to work with. But sometimes the hospitals would say, we don't like abortion. So if you're an abortion doctor, we don't want you here. So on that basis, some doctors could not get admitting privileges. Sometimes the hospital would say, well, we'd be delighted to have you have admission privileges here, but we only have room for so many, and we're full, and so we don't have room for you, and so on. There are just a lot of reasons why getting the admission privileges is difficult for doctors, and the numbers as they add up turn out that in this particular case, that requirement would close almost all the abortion clinics in the state because the doctors could not get admitting privileges at nearby hospitals. Therefore, they couldn't practice. They couldn't practice at those clinics, and the clinics had to close. Well, that meant for the women involved, much longer distances to go, not just in our neighborhood for a hospital or for a clinic, but not even in our town, maybe not even in our county. And if you live in a place like Texas, you might have to go 300 miles to find a clinic. And then if there are additional restrictions like, well, you have to have 24 hours waiting notice, that means you got to stay overnight in this place in Texas. Meanwhile, who's taking care of your children at home? There's just a lot of reasons why these kind of things, limiting the number of clinics, is a very substantial problem for many women. Not all women. If you're rich enough, not a problem. But if you're not in that category, then it's difficult. The law says, Roe against Wade says you have a constitutional right to abortion, and state restrictions on that right cannot produce a, quote, undue burden on your right to have an abortion. So the question of all these restrictions is this an undue burden? Very vague term, but the courts have sort of looked at it and said, well, if there's no health benefits to this thing, as probably the case with admitting privilege requirements, it's probably an undue burden because it will limit the number of clinics in the state and vastly increase the cost and expense and time to the woman of finding a clinic. So there's a serious cost involved to the woman. There's no health benefit to the woman. We think that makes it an undue burden. And that's kind of the way that cases are arguing. There are different theories by different justices, but this is, I think, what's going on. Well, in this case, I told you the case that came up 2 years ago from Texas, the court had stricken that restriction on the grounds that it was an undue burden to require admitting privileges. And this one from Louisiana is almost word for word the same as the Texas statute. And in the Texas case 2 years ago, Justice Roberts dissented. He thought the restriction was okay. It was not an undue burden. So he dissented, but he lost. And so the case stands for the proposition that admitting privileges is not something you can impose on these clinics, and it provides an undue burden for the woman, and therefore it's illegal. And Justice Roberts did not agree with that, and so he dissented in that case. Well, the same case now is before the court, and four of the justices, the more liberal ones, say, look, we decided this 2 years ago. It's all settled. We've already decided it's an undue burden to have admitting privileges as a condition of operating in a clinic. But they only had 4 votes. So Roberts doesn't join their opinion, but he writes a concurring opinion, concurring in the result. That's really interesting. And it tells you something about Justice Roberts. He says, I still think it's a bad idea. And I did 2 years ago, and that's why I dissented. But it's now the law, and we have to follow it. It's stare decisis. It's following precedent. That's what we do in courts, is follow precedent. And so, while I think it's wrong, I have to follow it because the court decided it 2 years ago. Now that's an interesting notion. I mean, it's honest, and I think that's really important to think about when you're thinking about when Justice Roberts might stand up and reverse a case, Roe against Wade. He doesn't seem to be interested in reversing cases. He seems to look for, being faithful to whatever the court decided most recently in a similar case as being binding on him. So it's an interesting notion. So where are we with respect to abortion cases? Well, we don't know, but it is the case that these restrictions keep coming. As I say, there are many, many of them, and there'll be more litigation about them. But the standard is easy to state. Restrictions on abortion are okay unless and until they produce an undue burden on the woman in her effort to accomplish the objective that her right entitles her to. And that burden is going to be assessed in terms of its cost to the woman and whether or not there are any health benefits. And so I think we're going to have a lot of discussion of those kind of things. And there's some other theories around too. Okay, before I run out of time, I should mention the immigration field. The DACA case. DACA, you remember, is the Deferred Action for Childhood Arrivals that President Obama put into effect in 2012. And it says to these youngsters who were brought here by their parents illegally when they were very young kids, and they've grown up in the United States, and they've kept out of jail, they've gone to school and do all the right things. And so the DACA provision basically says it's an executive action, it's not a congressional enactment. Obama tried to get Congress to act, Congress refused to, so he did it by executive order. And it basically says to these kids, dreamers we call them, if you apply for this status, we'll give you a 2-year deferment of any possible deportation. You will not be deported for 2 years. And we'll give you work permits, driver's licenses, Social Security, Medicare, student aid, other things that are available to most people. And that for 2 years. And then that's renewable at the end of that time if you're still in good standing. And good standing requires that you came to the country under the age of 16, you're in school or the military or something, and you're not been convicted of any serious criminal acts. And so that's being litigated because people say, well, the president hasn't the authority to do that. And while that is in litigation, you and I elected Donald Trump, and Donald Trump comes along in 2017 and rescinds the whole program, issues an executive order, that wonderful signature he's got, saying, well, I'm rescinding DACA, period. Well, that act now comes before the court this term. And what's the result? Well, again, like a number of the other cases, it gets rescinded for further work to determine whether or not it's arbitrary and capricious, which is the statutory standard that these things have to comply with. But I think the point is that the court says the president does have power to rescind an action that a prior president took. And so the rescission is within the power of the president to do it. He did not, however, follow the correct procedure, and that's what has to be determined now, what the procedure is. So it'll go back and they'll decide whether or not the procedure was followed. But it does mean that the president clearly, according to the court, there's a 5-4 decision by Roberts. The president does have authority to rescind. So if he's president after November, that rescission, if he can explain it and comply with the procedural requirements that haven't yet been tested, then the rescission is valid and DACA is dead. On the other hand, if he can't come up with a way of meeting those procedural requirements, then the rescission is not valid. DACA is alive and well. And if he's not reelected, then who knows where we're going to wind up. So there's a lot of uncertainty here that we'll have to sort of work with. The fact is, right now, the matter is on hold, and the courts are now saying, lower courts have said, since this decision has come down, the DACA can continue to accept applications from dreamers. So the program is sort of alive and well right now until the further judicial process works its way out in the slow, methodical way it does. And it is, again, the sort of thing that we just have to wait and see. But right now, if you're a dreamer, you can go ahead and apply for this status and get started on this process. One of the things that's looked at in the case of the further procedural requirements is to establish that the decision that the president made was not arbitrary and capricious, the statutory standard. And that's going to look at stuff like, for example, can you rescind something when there's been very substantial reliance on the existence of the program to people's detriment if you suddenly cancel it? And so in all these briefs, you'll find all this discussion about what the dreamers have done. And they've grown up, they've gone to college, they've gone to medical school, they've gone to law school. They have, thousands of them are working in the healthcare fields. They have been in the military, they've done all kinds of things. They're having 200,000 children of their own. And their own children, of course, are American citizens. They're born in the United States. So who do you deport? And it seems to me that this is moving down the track. We'll just have to kind of see how that works. Anyway, but these people have done all kinds of things, and it's quite a remarkable bunch of people. 800,000 of them applied for and got the status as dreamers, and presumably now that they can continue to apply for that stuff if they meet the requirements. And then we just don't know what's going to happen next. It depends on how the court behaves and who we elect for president next time. If we have a new president, this case does tell us that the president has authority to rescind the action of a prior president. So even if this rescission turns out to be valid because the president can show it's not arbitrary, a new president can rescind it. So uncertainty seems to be the name of the game. One final observation about the court. I've mentioned a couple of times that Roberts seems to me to be an incremental conservative. That is, he likes to take small, measured steps, not broad principles, not huge jumps. with small steps. What's the narrowest basis we can get the right result here, leaving us the maximum amount of freedom in the future. And so, as an incrementalist, I think that's his style. He's a conservative, and I don't think you should doubt that. He's not getting more liberal. But I think he does have the ability to think as an incrementalist, which I think is good for the court. I think one of the things you get from this term, with all of these different permutations, is that there seems to be a little more consensus on the court, fewer 5-4 decisions. They usually have about 30. They only have 20 this year. They're more like 6-3 decisions and 7-2 decisions, which implies a little more consensus. And some of us think, you'll never know until we get the memoirs, I suppose, but some of us think that Roberts has this effect on the other members. He encourages them not to go too far in their claims, not to be too extravagant in their arguments, making it possible for arguments to overlap, and so you can get more people to sign the opinion, and reducing the range of conflict by careful drafting of opinions. And I think there's some of that going on. You see a couple of justices who came down on a side of this that you wouldn't have guessed about until you read the actual opinion. And when you see somebody's written it very carefully so that people with quite different views can nevertheless sign it. And I think that's the kind of skill that Roberts may have, and it may be something that is we're going to see a lot more of. So that's my take on the court. I think it's to me it's a good idea because it permits the court to behave more like a court and less like a partisan debating society. And for those of us trying to predict outcomes, it was kind of nice to have 4 you knew were going this way, 4 you knew were going that way, and then you just had to persuade the swing guy in the middle or a woman in the middle which way to go. That made it fairly simple for counselors and advocates to design their cases. I think it's going to be much more complicated as we get shifting alignments and shifting arrangements and broader understanding of what the role of the court is. I'm sorry this format doesn't permit questions and answers, and because I would love to talk to you about some of these things. My name's in the book, Bill Andersen. My phone number's in the book. My email's in the book, and I would be delighted to hear from you if you have questions or thoughts about any of this stuff. Thank you very much.